complete. Okay. If anyone has issues with being seen or heard on the recording, please send an email to jp@lawfidao.com, or if you feel comfortable to put a note in the chat, I can make sure that the video is edited in that way. Well, thank you everybody for registering and supporting the first DAO Day and first workshop of LawFiDAO. It's a bit elusive to date. Yes, pause for clapping. Welcome to all of those that are slowly trickling in. I am delighted to be here with you today and with a genuine group of peers, mostly from the Australian community. There are a few that may dial in overseas if their alarm goes off in time. And that is the intention, that it will, and the reality, that it will start off likely as an Australian project and will take some time to be sufficiently globally decentralised and fulfill that part of the D in DAO. Now, there's a cute little moment that we need to have before we get into more of the detail and the name. Where did LawFi come from? Now, if you spell law firm and remove the RM, you get LawFi. It's as simple as that, but it's quite cute that in programming, I understand that RM stands for remove. So we're just adopting some programming techniques on how we're attempting to do law and law firms and the delivery of law, governance and policy differently. So you all know me from my work in blockchain and digital assets and supporting Web3 policy and DAO first thinking. It's all a bit elusive. Nobody really knows what's going on. All of the DAOs seem to be doing things differently, but there's a lot of people involved in them and purchasing their tokens. And as a lawyer and a trained tax lawyer, I'm disheartened by the lack of information and good information that is still not out there, and seeing the struggles around resourcing of regulators and policymakers to bridge the gap and help provide updated and informed guidance in an agile and a dynamic manner to keep pace with how quickly this technology is emerging and different governance structures are unfolding. So I present this proposal to you through me, but it is the combination of 6 years of work in this area, talking to each and every one of you throughout those years, and that's why I struggle with the word founder. You might have noticed that I used the word creator spirit when I signed off on the invitation email, and that's intentional from a legal perspective, to recognize that there's no point of centralization in me as the person that wants to control or seeks to control the decisions and the projects and the activities undertaken in the DAO. It is an expression of what might be written by me, but with the input of all of your ideas and the knowledge that you've shared. And in that sense, I've been learning a lot of late about First Nations and Indigenous cultures. And it really strikes me that the reciprocity which their culture has taught from time immemorial, we haven't had that in the way that our corporate organisations form and are registered and are run. And now through a number of the ESG efforts, we're seeking to back solve for that reciprocity, where we haven't been mindful of giving back or restoring the land or the office or the workspace to how it was when we found it, or in a state that's better. And so that reciprocity, driven through just basic decency, common sense and respect, but also what we're learning as more and more of us understand First Nations culture, and particularly in Australia, as we have the Uluru Statement from the Heart and a progress towards a referendum to enshrine a constitutional voice in Parliament, having a First Nations cultural and creator spirit theme and foundation throughout the establishment and the running of this DAO is really important to me and a number of peers that are on this call. So through all stages of this DAO, there will be discrete legal products and projects, but that creator spirit is something that is in addition to or above a typical mission and vision of a company. And that is intended to be respect, reciprocity, integrity, and kindness while we're doing things differently, and appreciating that our time is our most precious resource. So with that opening, I would like to acknowledge the traditional custodians of the lands in which we all meet. I'm on Wurundjeri land, and I respect the elders past, present, and emerging. The land, at least in these parts, was never ceded, and we have much to learn from their continuing culture. Please feel free to put things in the chat as I go through, and I'll try and address any questions, because I'm nervous, as you can probably tell. I'm usually the lawyer behind the desk, and or in a one-on-one conversation with each of you, and this is definitely not my natural state to be the creator spirit of a DAO and putting myself at the front of a community, at least in the initial stages, before we get a more formidable spokesperson. So I really thank you for making the time to join me here today. I hope that you will find the time and the place to contribute in some small way to give to the community. It is directly to Lawfy DAO, but it's hoped that the resources and the projects and the things that we do have ripple effects and benefits for how DAOs are conducted and how people around the world learn about them and interact with them. So the objectives of this DAO are to educate. It's an ongoing educative experiment to educate the public, policymakers, regulators, and our judges about DAOs, or whatever name they come to be known as. I'm already seeing petitions and proposals to rename them as democratic autonomous organizations rather than decentralized autonomous organizations. There's also the policy issues and the opportunities presented by the nuances of this technology and its consensus mechanisms, from proof of work to proof of stake to proof of you name it. All of those throw up different legal and tax challenges, which we're struggling to grapple with. And the automation of smart contracts bleeds us into similar fields of artificial intelligence. If the code doesn't run as we intend it to, or it's exploited, who is responsible at the end of the day? Is it the developer? Is it the governance council or committee that voted it in? Is it all of the members that could have voted differently but didn't because they were apathetic and not really involved in the DAO for the right reasons and just for speculative gain on the token? Or does it go further or differently? We still haven't had enough guidance to answer these questions very clearly. And my heart breaks with every person that comes through and says, I would love to do a DAO. This is my idea. And we go through the legal frameworks and the possible tax treatments, and there's too much risk at the end of the day. And so the founders that have launched DAOs and that are trying to maintain and operate them, I have a lot of respect for, because they're doing so with great legal uncertainty. A number of them have partners, families to support, and that uncertainty is not great for anybody's mental health, no matter how much of a risk taker you are. So education is a key pillar. Another is to promote behaviours that contribute to improved mental health and well-being of our people involved with DAOs, but particularly for those involved with the legal profession. We've had a number of criticisms. You'll see lawyers working endless hours to get those billable hours up and participate in the rat race, climb the food chain, and seek to get a higher level of income to pay off the mortgage and give your kids a good education, is essentially the gist. And so that rat race is not just in law, but the pressure is too much in my mind, and not enough inertia is being placed on law firms to change that model. And so the delivery of legal services continues to become strained. Access to justice becomes strained because access or the affordability of law and legal services is becoming out of reach. I myself went to a counselling appointment the other day, which was $250 per hour. But I, as a lawyer, and that's mental health, but I, as a lawyer, charge upwards of $700 an hour. Am I in that privileged of a position in society that that's okay? And it's confusing about whether this is a public good or not, and the function in which lawyers are supposed to play. If laws are supposed to be the codification of social norms, and we're supposed to assist public and private market participants to observe what those social norms are, how did it become that we charge such a high premium for maintaining good order in society? Maybe that's okay with private sector and commercial enterprise, but I don't think it holds in a lot of situations, and especially where innovators are cash strapped and the same legal advice or very similar legal advice is being given over and over again, or could be, but it's not being picked up. That to me is showing that the market is failing. The market is also failing because a number of DAOs are launching without legal advice and without legal support, and people are obtaining tokens and being involved and contributing to DAOs without thinking about the legal and tax consequences. Regulators aren't moving to change that quickly enough, nor are policymakers. It's been 8 years since the crowd sale of Ether, and still regulators are arguing whether it's a security, a commodity, a currency, or property, or needs to be a third form of property, if you look at the latest consultation by the UK HMRC. So we're confused, and new law or amended law is probably a number of years away. So something is needed to bridge the gap in the meantime, and also to do so in a way that promotes good behaviours. So Lawfi DAO is intended to instill DAO Day, so that every Friday, whether you're in a law firm, in a university, in a regulator, or a policymaker, you can devote some part of the day and be part of a community that is activated on that day to further your understanding and interests. And it is my hope that employer organisations give their people the space to further their intellectual curiosity, but also contribute and give back to the well that is responsible for feeding that curiosity. And that's where the reciprocity comes in. I think that Lawfi DAO could be a new form of self-regulatory organisation globally that can move more quickly and more dynamically than any one national government or regulator. If we can design frameworks, and we'll get into what some of those frameworks and the legal products might be, then this is a global model that will have incentives and token-based incentives around it to build communities, to incentivize lawyers to be preparing these materials, but also all of the institutions and individuals and other market participants that want to receive the benefit of this thinking, they irony is that they have a central place to come to access a repository of sorts, and where that information is available. A rising tide lifts all boats. Louise, I'm looking at you because you helped me with that quote yesterday. And I think that up-to-date, agile, dynamic information in this space is what is needed, at least to bridge the gap in the next few years and lift the standards that ultimately do try to put in place minimum and best practice standards. And again, get us to an understanding and criticism and critique of what are the social norms that are worthy of codification in new or amended law, if we seek, or if any one national government does seek to regulate DAOs as global beings and blockchain technology. I'll pause for questions in a second, I promise, because I want to welcome community feedback. So the lacking or the criticisms against existing centralized entities and institutions it does center in on the disconnect between how the managers and the information that they receive to make their decisions about the strategic direction of the company, how we can also bridge that disconnect between the employees and the shareholders and the stakeholders. So effective corporate governance is already in the spotlight, and DAOs give us a vehicle to experiment as to how this can be done better and differently, including with incentives. So one of the key projects of LawFi DAO, which I think will take the first 2 to 3 months to explore, is a membership/an identity token, which goes to also supporting representative democracy and equitable outcomes based on an understanding of diversity, inclusion, and equality in a DAO community. So if you filled out the EOI form on the website, one of the last questions is, what are your attributes? What makes you you? And it's interesting to see some of the responses coming through already, but who we are, who is our identity, is not one thing that can be defined by a government or an institution. In my view, and a number of people's views, and I would love John to speak up when we get to the community discussion, identity should be the collection of your attributes and your experience and your social graph, who you surround yourself with, their character, their experience, and your lived experience. So when we start talking about the membership token of the DAO, when it is ready to be released, those attributes should be front and center, so that when we do need to have a vote, it's not just a matter of 75% of our members voted. We can also get a sense of this was the proportion of women or First Nations or those with a disability. And all of a sudden we start to actually understand whether our decision-making is being inclusive enough, or whether the DAO can act differently to encourage those audiences or representatives for those audiences to participate in decisions that will affect them, especially marginalized communities. This is also relevant to what is the analog version of LawFi DAO. We will predominantly meet virtually and through digital mediums. So we may use Jira, we may use Discord, we may use a number of things to communicate, but there always needs to be accessibility in an analog version too. So that's up for discussion. And then a final objective is to experiment, observe, and reflect on how the legal industry can better support understanding and compliance with our laws by those that are involved with DAOs and blockchain technology, how to input into the development of these minimum and best practice standards for those involved in DAOs and blockchain technology, and whether we can be dynamically involved in improving and simplifying laws as they might be applicable to DAOs and blockchain projects. So the projects. I've mentioned the membership identity token. and we'll get into more of that shortly. But another project is simply the establishment and operation of this DAO. What does it take? What is unseen before you are allowed to participate in a token distribution event, or you purchase it on a token exchange? What are all of the things that have happened or that have not happened? A lot of people say when you're purchasing a token, do your own research. But a number of people then say, I don't know how to do my own research. Where's the due diligence model and framework and investment thesis for me to judge whether this is a safe investment, whether the team has dotted the I's and crossed the T's? Are they being transparent in what they report out to the DAO and what their token holdings are? Because there's no verification of how many wallets they're using to hold tokens, for example. So all of these questions, or a number of questions, I hope to have in public with you as I'm going through this process of establishing the DAO. And not enough of it is talked about. But to be truthful, it does make me nervous because it is being launched earlier than I would have liked to, so that you get the benefit and the community gets the benefit, or whoever wants to purchase this product, if we decide that it becomes a product of this learning and making this upfront and accessible about how messy it actually is, which is the same for startups too. But startups do not seek to be global from the get-go and with a global membership base. The key thing here, the key project or the operational project, will be the introduction of a pay-to-rely framework. So if I'm a startup, or if I'm intending on launching a DAO, I might typically go to a law firm to get advice. Is my token a security or a financial product? Is the common thing that comes first. Now, this advice is often private and confidential and subject to legal professional privilege. So the team is not supposed to talk about it or reveal the contents of the advice. Otherwise, they would waive that precious privilege. Instead of that approach, the pay-to-rely framework would mean I can see that Compound or MakerDAO, I'll use MakerDAO as an example. Nobody knows, there's no public documentation that says, yes, MKR is a security for these reasons, or is not a security for other reasons. And that advice would have to be given per jurisdiction. So across the US, Australia, a number of places across Europe, pick your country. So it becomes very cost prohibitive for a project that seeks to launch globally to get that advice in every jurisdiction. If we can come up with a framework that encourages, and I'm going to pick on you, Mike Bacina, Mike to be a core contributor to LawFi DAO. And it wouldn't be Mike, it would be Piper Alderman as the law firm. He would write an Australian legal advice to say, in my view, supported by Piper Alderman, and I'm just making this up, this is hypothetical, MKR is not a security or a financial product for Australian legal purposes. And then all of the reasons and the justification, references to case law and available regulator guidance would be referred. That could be made publicly available for either everybody to see or people that pay to join LawFi DAO, kind of the law path model where you pay a fee and you've got access to all of the templates. But the key thing is you might be able to see it and the market standard lifts because we all now have a public opinion out there, not from a regulator, but from a law firm applying the law independently and objectively. And if a token exchange or a superannuation fund or a financial planner or another organization, even an individual, wanted to rely, or for their business model needed to otherwise get legal advice and wants to rely on that opinion, they pay to rely. They would likely pay with ETH, and in return for that payment, they would receive, I imagine, an NFT in return that represents their right to claim against the DAO in the event that they suffer any loss from that reliance. So if a token exchange is the one that purchases or pays to rely, and the Australian regulator, ASIC, knocks on the door and says, we feel this is a security and you have listed a security without having an Australian markets license, therefore you will suffer this penalty, that would be grounds for the token exchange to claim against the DAO. Now, this is the reason that the revenue, that pay to rely ETH revenue, would be split at least 4 ways. A portion to the core contributor, so Piper Alderman in this case, a portion to a peer reviewer pool, so other lawyers and law firms would be incentivized to review and agree or disagree with that opinion. The more peer reviewers you have, the more robust and the more reliance the market might think that they can place on that opinion. The third is to a self-insurance pool to fund any claims made. And the fourth is, or could be, a revenue sharing pool. Now, this could be a mechanism to raise funds, for example, for law firms that are seeking to get the edge. And if there is some chance that LawFi DAO could be the inertia that disrupts the traditional law firm model, as a hedge, they might seek to acquire LawFi DAO tokens, however we conceive them. And in DeFi, typically you see that there is an exercise required for them to stake those tokens or lock them up in order to get a portion of the revenue distributions or other yield or returns that might be determined if extra tokens are minted as part of the supply to incentivize more attract or people to be attracted to support the DAO. And when that's happened, there are generally 2 reasons or 3. It's to incentivize distribution of governance so that more people know about the tokens, more will acquire it because they're attracted to the potential rewards around the scheme, even if short-lived. The second one is as an attempt to either prevent market manipulation or a form of market manipulation, because the locking up of tokens does prevent the circulation of otherwise tradable tokens. And then thirdly, it's intended to be a sign of confidence that the longer somebody stakes in the DAO, the more confident they are that it will have medium to long-term success. In other words, that their investment is not at immediate risk of loss. So that, in essence, is the pay to rely model. And it could apply to opinions around whether something is a security. It could apply to the tax treatment of a token. It could be disclaimers to accountants that are really unsure about doing crypto tax returns, and helps them to protect themselves if clients aren't forthcoming or they haven't kept accurate records to properly document and then for the accountant to determine the tax treatment. There are a number of various legal products that we could come up with. The framework would be to support lawyers around the world to do that in step, so that you don't just have Australian legal opinions or tax opinions. At the same time, you also get the US lawyers involved, New Zealand, and finally we start to get a harmonized organization that can move quickly and in step with an incentive model that no current regulator has. The allocation of resources to them has to be balanced with a number of other priorities. So that's the proposal. And even if it fails, I think that putting it out there and testing it will lead us to the next best thing. So why not have a crack? And the final, so there's pay to rely framework, the membership/identity token, the establishment and operation of a DAO, and the marketing and community building. So how do we do that across both virtual and physical environments if we truly attempt for this to be a global being? Very quickly, there was a very subtle GoFundMe campaign which a few people found out, and thank you to the likes of Electra and Gordon, and that shared the GoFundMe page, and people like Nathan and Mark that contributed to the GoFundMe campaign. We raised $8,500, which again, we can decide how to best spend it. My feeling is that it could be towards the developer that is necessary to design and deploy what the identity and the membership token is. But that was an experiment in itself as to the reason why we do need to market a product, because you're not going to raise money if nobody knows about it. And it was also an experiment of how much money could be raised without the FOMO or the hype of a token necessarily being involved in the fundraising campaign. So I suspect that we probably would have raised more if it was a token, but I still think that the experiment has proved itself. Or maybe we'll do a split test down the road. So housekeeping, how to join and contribute. At the moment, it's the EO, the expression of interest form on the website, and very like a JOT form, membership application form will follow. At this point, this is cause for reflecting on whether you sign up as an individual or through a limited liability entity. This is an unincorporated association at the moment, and after this presentation, the rules of the association will be posted. Now, this is in contrast to a typical DAO launch that would share its white paper first. But I think that the white paper is something that needs to be developed and settled after the rules. And in fact, it could even cause a reason to have a meeting to adjust some of those initial rules. You'll see as one of the first products of this DAO that the rules of the association, or the rules of the DAO, are based on the model rules from the Victorian Consumer Affairs organisation, as if it was an incorporated association. So again, we can go through the exercise of attempted compliance with Victorian laws, whether the tokenomics model or an initial tokenomics model would pass registration with the Victorian body. Once you have 5 members or more, you're required to incorporate the association. A number of DAOs don't do this currently, either because they don't know or it's impracticable to do so. So there will be some instructions. You can see the track changes that I've marked up against those model rules to adjust for some of the nuances of operating as a DAO, but there's further things that need discussion in the community and to settle on how we do want to operate, and how much we want to depart from the existing laws and our reasons for why, such as the disciplinary committee, any disputes needing to go to a Victorian arbitrator. Would we instead want to have the benefit of the dispute resolution protocols that are being experimented with or that are tried and tested? Should we reserve the right to do so at least? And should the law allow us to do so if the community is told up front and accepts that? So these are all of the sorts of things that it might seem boring, but I'm sure that there's a sector of the population, and particularly the lawyers on this call, that will relish in these discussions, and all of the benefit of that thinking can be available for anybody who chooses to access this content or pays to rely at a future point in time. So there will be then a framework for contribution to tasks, but in the interim, any agreements to provide products or services to the DAO will be made directly with the secretary, which is me at the moment. Another report is that I attempted to register the unincorporated association, or the DAO, for an ABN, and was swiftly issued a refusal notice by the online software because the answers provided, and I'll make that publicly available as well, they just don't fit the mold. We're neither in business nor are we eligible or fit the clear requirements to have an ABN, which affects our ability to apply for a tax file number and do tax filings, and could limit our ability to pay suppliers in the right way, and just comply with basic things that you need an ABN for. For feedback and discussion, which I'll open up shortly, I would love to ask some direct questions of those that have been able to make it today. When we send out the membership form, should there be a joining fee? With the membership token, should there be a subcommittee elected even today? With the other tokens and the tokenomics of the whole model, what kind of governance process should be around that? And should we try to have regulator pre-approval around that before we launch it, so that everybody following can get the benefit of a project that they can see in clear day what the sentiment is from each and every regulator that would be involved in the process. And then the regularity of workshops and the ongoing election of committees. So I know that is a lot to take in. The documents will flow, there will be forums for discussion, but again, I just want to thank all of you for making the time for what is a very, very early stage project and an educative experiment. So thank you, and I'll open the floor for anybody who has feedback on the model or questions, and then we can get into specific projects after that.
Joni, I have a question.
Andrew, yes,
hi.
Welcome.
What consideration have you given when you went down the rule of looking at rules of association and modelled on the Victorian Incorporated Association model? Did you also have pause to look at cooperative law and whether that was also an option worth looking at?
I did, and my feeling was that cooperatives are the lesser known or lesser used vehicle, that it's more likely, a DAO is more likely to be run and operated as an association and then perhaps as an incorporated association. There is less familiarity with co-ops, but they may actually be the better legal structure for the majority of DAOs. So we can seek to interrogate that in a working group or in a subcommittee. And I think that that's a very good discussion to have to help people make the decision, particularly because co-ops can have specific tax concessions, which associations do not. The association...
Yeah, I raised the question because looking at the faces on this call, most of the people here are too young to actually know how successful cooperatives have been in the past, and how long they've been around, and how what technology makes possible in terms of giving them a new generation life. And there is established an existing cooperative law in this country, which is nationalised, which unfortunately does fall at a jurisdictional level at state government level, which does make it a little bit problematic in some spaces. But it is a model that does work, that you can get through to get a bank account. I've personally done 5 of these where we've worked through and got an ARBN through the model, which means you can have a fiat bank account. So it might be something just to have a look at. I don't know, there's obviously pros and cons across the whole lot, but it'd certainly be something worth looking at. And certainly from our own company point of view, we are very much, because a couple of us come from a cooperative establishment background and we're not lawyers, we are looking at how we could take the principles that are associated with cooperatives and put them into a DAO framework. So
I welcome that contribution. Samantha, yes.
Hi. Can I just add that in backing up what you're talking about, the farmers area, which is where I'm in the farming space, has long used cooperatives for much the same thing, particularly for resolving ideas, and they often have quite large stake in things. And I looked at doing it for land acquisition and putting it into the blockchain as well. So I would second that as a recommendation, Andrew, as I think the cooperative model is definitely the best thing to look at from a freedom of access. And also I did look into it from a legal point of view around the blockchain, and I think it's a really good model.
Thank you. Well, I think we need to make a note of that, and please, if you want to volunteer your time for any of these working groups, either send an email to jp@lawifydao.com or in the chat, and I'll extract it later and get in touch with you. Anybody else with comments on association versus cooperative? The other thing to note here is a number of DAOs structure themselves having a incorporated entity as a service entity, or a trust structure to hold all of the assets of the DAO, which might include the treasury or a segregated amount on account of making grants, and the IP, the trademarks, which we've had some experience in the Australian IP regulator, IP Australia, that they were not willing to register a trademark in the name of a DAO, nor in the service company, if we said service company in respect of or as delegate of the DAO. It had to be in the service company in its own right. So that is also an option. But if you're seeking to have a structure that allows most flexibility and most freedom to experiment with corporate governance principles and learn from what the Corporations Act might say around directors' duties and corporate governance, but not be bound by it, we still are stuck in that grey area of how much freedom does an unincorporated thing actually have, or will it be a deemed legal entity for legal and tax purposes? Barry, did you have a question? Forgive me if I've seen that incorrectly.
Yeah, when you were talking about, sorry, I'm just trying to think what you're talking about.
A lot of things.
Yeah, about being association and then dealing with financial matters. In terms of a DAO in making decisions and voting, I mean, can you just operate like a consultancy where there's like a kind of gap between decision making and decision taking? Does that make sense? Like, sorry, decision kind of creating and then actually making the decision and taking the decision forward.
You could. I mean, we could outsource it. Some DAOs have a number of internal and then external committees, where the external committee are a series of professionals that are sought out to give the advice or advise the DAO, and they will write the proposal, and that's what's put forward to all of the token holders or all the members to vote on. So there can be any number of hybrid approaches to get the right level of expertise around what the decision entails and how to protect its members or support its members. And that's the thing, because there is no set model. There's no template for providing services to a DAO as if you're a normal consultant or an independent contractor, or if you wanted to act as an employee. It's very fluid, and it relies on really the experience of the founding team or that creating spirit team to determine the extent to which they want to leverage from existing legal precedents and documents, or if they want to go all in or all native, where nothing is documented, or it's documented in Telegram messages and emails, which is not something that I, as a trained lawyer, I think that the legal process also gets you to certainty of what the meeting of minds is, because one person can write a Telegram message or an email and a response is given that they agree, but neither party has turned their minds to the foreseeable consequences of that arrangement and documenting the detail. And that's where lawyers, I think, do provide a public good and a function of being experienced in same or similar deals and contracts, where they can say, have you thought about an indemnity, or have you thought about if you're providing a service and you can't deliver it anymore for whatever reason, how are you going to terminate on it and still maintain a relationship with each other or continuity of the project? So I don't agree that we need all of the bells and whistles of what legal documents are today, but the storytelling and the experience of lawyers, I would like to see more involved in DAO design and protocol design. Sean. Forgive me, I'm seeing the screen highlight. So if I've picked on you, it's only because I think that you want to ask a question. I might, Sean, if you're wanting to speak up, I might just deal with some of the questions coming through in the chat. Well, that's okay. Oh, lovely comments initially. Relax, yes, that is true. I know I'm being a nervous Nelly, but no worries, Louise, for dropping off. Barry, yes, we've dealt with your consultancy question. Can co-ops be for profit? I imagine, I would defer to Andrew here or Mike, but I think yes.
Yeah, from my understanding, they can, and that's why I think it's a good model as well. And yeah, the profits are shared back to members as opposed to companies. Profits go back to shareholders.
Yep, they can, Joni. The model to look at is the distributed co-op, which is not what most of the co-ops are. So that's something we can take offline but look at. But that does give the ability to still retaining a one member, one vote paradigm. It also gives the ability to distribute profits back to the members.
Yeah, that's what I found when I did all the research as well. It's just seemed to be across the board the best model for a whole lot of reasons. And it was underused. The co-op model seemed to be almost outdated in terms of everybody using it, but it's very old-fashioned and it's been used for years, as you say, Andrew. You really see it in the farming area, but some of the co-ops failed when they got very big. So I think it's about maybe there's something in the size part of it, or how much. One of the key things, as I understand it, is that the members have to be active. So if they don't reply, and I just don't know in a DAO thing how much people do actually vote or reply. And I think that was one of the limiting factors, because a lot of crypto people, set and forget. And I don't know how much that's the factor in this area.
Well, that's a key point, Samantha, and I might actually bring Greg Oakford to talk about one of the pieces of technology that is being developed, because if our membership token is an NFT and it represents our attributes, you don't want to have to check in every day or multiple times a day when there is a vote that really could benefit from your experience and how you might vote. So, Greg, what was that technology that is being built by the projects? Probably something that basically is a dashboard that notifies you when there is something you would be interested in.
Yeah, it's the product. It's in beta at the moment. It's called Lifeboat. I'm not sure if it's related more on the DAO side at this stage, but more on just the problem in NFT land. If you're in a gazillion projects like I am, and there's airdrop this or claim that or get your tips in for this project or whatever it might be, it's a nightmare to be across every Discord notification or Twitter or whatever. So this particular piece of software has developed a dashboard where it essentially, and you have some autonomy on it too, in the sense of if there's projects you're in that this software discovers from your wallets, you can mute certain projects. So if you're not really worried about certain projects, then you can just mute them. But for the others, from what I've seen in early stages, it literally only got released about 5 days ago. But yeah, it looks like something that would be handy to me personally, but I'm sure that that could be rolled out more in a DAO sense. I even saw the founder, Nat Fax. So I think her Twitter handle is at natfax.eth, or that's her handle, her Twitter name, I should say. She said that, yeah, there's a potential down the line to solve communication problems in Web3 other than traditional email, which is obviously more of a Web 1, Web 2 mechanism.
Yeah, and that's one of the key things I'm finding about participating in Web3. It's my choice to log into the Discord and check the various servers to read the updates about what's going on in a project. Whereas Web 2 or the centralized companies, all of the marketing campaigns are via email. And I just feel bombarded with that push into my world. And maybe that's okay for the alerts that I want to be set, and I can more actively manage that. But the default is market through pushing out, whereas it's a very nice change to just, in my DAO days, explore the DAOs that I'm interested in or I want to hear about without being pushed the information when I'm not ready or not open to hearing about it. So thanks, Greg. And on that, those of you who were just a few minutes after 2 p.m. joining, for those that are in attendance today, you will be getting the first Lawfi DAO POAP, and we have Greg to thank for arranging that in quick and good order, and Vic Wells, who I think is still on the call, and BB Barber have provided the artwork for us. So an email will go out after this video call with instructions for you to claim. So thank you, Greg, Vic, and BB. So just going down through the chat, Kelsey, thank you for that article. If you haven't had a chance to read Kelsey's work yet, please do. She is a thought leader in this space. Same for Ellie. On that note, Ellie is also on the call. Please follow her. David, for co-ops, it is different legislation that not many people are familiar with. Correct. More people are familiar with associations, and the experience has been that members provide goods or services. So not sure how that would work here. Both associations and co-ops usually have 1 vote per member. Agree. So let's mark that down as a subcommittee, and we can flesh out the pros and cons as between association versus co-op. I'm combining POAP and co-op, too many acronyms, and we'll document that for the benefit of the community. So Zubin, you have a question on the A part of the DAO. They can.
Yeah, so sorry, that was a separate answer on the co-op thing. Yeah, thanks, Shirley. And I've got a cough, so I'm going to try and keep this very brief. Just a question, and I apologize. Thank you. I missed the first several minutes. Actually, I was stuck on another call. How are you planning to do the autonomous part of it, and how are we interpreting the word autonomous? Is it resistant to some sort of control or censorship resistance, or are we interpreting autonomous here to mean self-executing via code?
It's in a couple of different respects, and it's just an initial proposal subject to further discussion. But one of the ways in which the legal products might be supported by an autonomous process is to do with data analytics. And so I'll throw to John Studley in a second, because he's the resident data analytics person in this group. But if Mike Bacchina was to write that legal opinion we spoke about early on, and he says, I have relied on the public information from the white paper as at this date, the website, and provides links to all of those inputs of information, then it's my hope that we can work with the data analytics professionals so that when that information is updated, we get an alert about it. So Mike would get an alert, as well as anybody who is paid to rely, to say that it has changed. We haven't had a chance to consider whether it's different or the same yet, but please be on standby. And as the analytics and the oracles get better, then we could, in a sense, have a computer-generated assessment of whether the advice remains the same or needs to be changed. And perhaps in that period, there's a lesser fee for paying to rely or no fee. But that's a key part of making the deliverables have a life of their own and have a sense of being efficiently updated rather than requiring humans to put in that effort all of the time. Because there are 10,000 plus fungible tokens on the market, there is also a way in which we could approach this where through a collection of perhaps Australian law firms, we could get 100 different token opinions in the space of a 12-month period. And for the remaining 9,900 or whatever that becomes, the inputs or the framework also go into some mechanism that gives a computer-generated assessment of whether it's a security or not, for example. Now, that's just on the legal product side, but that when we get to the membership token and the attributes and calling upon our members to do votes in this DAO or to be called upon to be more representative in the democracy of other DAOs, that sort of meta governance autonomous operation, which again is an experiment, hasn't been really done well before, and which I would love to explore with this group. But the governance and making proposals, a lot of that will be human driven initially and supported by Web 2 discourse like technology before we can automate around our governance procedures. Does that answer the question, Zubin, or did you have any feedback?
Yeah, I mean, I'm constantly sort of battling between the lawyer in me and the engineer in me, and governance is notoriously challenging, mainly because security, scalability, as we know it now. In 5 years, things could be different. But I'm also mindful that blockchain is a technology that doesn't lend itself to as many use cases as people would like to believe, right? And I think the trade-off that all of us need to consider is, for the goals we're trying to achieve, how do we extract the most out of blockchain and not necessarily be married to it, right? But I'd love to hear. I think you'd refer to John Studley, who I can see is on the call, and whether he'd have any perspective on the sort of harvesting the data emitted off on and off chain in terms of the opinions and changes to opinion state.
John?
Yeah, no, thank you. Yeah, thank you. Quick comment would be, the good thing about Web3 and I guess Web 2 to some extent is that the digital breadcrumbs, if they're there, can be harnessed and used by machines to help monitor, provide intelligence, and also to either reactively or preventatively act. So it should be possible in a very transparent way to monitor movements of information, users, changes in user base, movement of the content, and be able then to set up the right sorts of alerts and early warning systems to allow people to know what's changing. It's quite easy if it's transparent. It's quite easy if it's digital. This requires the right frameworks and governance settings and privacy settings, I guess, to be considered.
Thanks, John. And I'm going to call both of you up to be part of the working group or the subcommittee later. All right, I'm just moving down the list, but I will pause for a moment if anybody wanted to or has to drop off and wants to ask a question out loud. Pause for 5 seconds. Good. All right.
I have to drop off, Janie, but the geek in me is trying to think about the machine learning opportunity that presents here. I'll go away and work on that in the background.
Good. Curiosity is sparked. Check.
Cheers.
Thanks,
well
John.
John, very quickly on that, John, before you jump off, take a look at the chat. I've just sent you a link that I think you might find quite useful.
Great. Thank you so much.
All right. Thank you. All right, John Phillips, touching on so many areas of personal and professional interest and digital identity, referring to the discussion around understanding what commitments have been made, consent. So John, would you like to please grace us with what you're thinking. What's going through your mind as you hear all of this?
So many things. Firstly, Joni, brilliant. I love the intro. I know you felt nervous, but you're doing an awesome job when you did the intro. And I think if I blend to the things that you were saying at the very beginning with the point about digital identity, just as a taster, I suppose, the journalist and I think really quite good author and great thinking person, Stan Grant, has written a couple of books that are kind of worthy of note in this conversation. One is, of course, Talking to My Country, but the other is On Identity. It's only a 33-page document, book, but it's a very powerful read if you want to get a sense of both the combinations of the things you were talking about that are important for all of us living in Australia, as well as the topics of identity. To which I guess I want to make a sort of suggestion that any of us that have spent some time thinking about identity, it's an absorbing topic. Philosophers have thought about it for centuries, and it's the idea about who we are is incredibly engrossing. But that probably isn't what this is about. What this is about is what do people need to know about us that is meaningful in this group, and how do we decide to recognize people that are members of a group and present ourselves to others? This sort of communication thing. It's not so whatever identity patterns we choose and attributes we choose are really only going to be meaningful in this context. We don't need to think of them as absolutely me, nailed to the nutshell, whatever. It's really about what's important in this context, so we can take off the kind of philosophical yoke of making it our lifelong identity. It doesn't need to be that. But I do think it's really interesting the point you're making about sharing in some sort of transparent ways things that others or we may find useful in our deliberations. Now, is it important to know where people have come from, what they identify as, and so on? Are these things that are important for our understanding about how the democracy works? Are we representative? Are we diverse enough? Questions like that. I think those are going to be very interesting. The other thing that you had me, and of course you were pointing to soul-bound tokens, and Kelsey and I were having a little chat inside about soul-bound tokens. I personally, I guess I'm wary, despite being a technologist, of launching too quickly into a technology solution. I'd like to think about what kind of qualities and outcomes you want before we choose the technology. But there is another way of approaching this, which is to kind of jump with both feet in and learn about the limitations or capabilities of the technology by just going for it and seeing how it works. So long as you haven't written things in indelible ink, or tattooed yourself with something, then perhaps it's all okay. So it's two ways of thinking. And the other thing that I touched on in my comment that this has got me so excited about is the way you were describing people's understanding of what their commitments are and the kind of mutual commitments that are being made in sort of a contractual basis. Had me thinking about a whole area that we're all kind of exposed to around consent in the online sort of sense of it, where in very rapid fire we're being asked to consent to various things when we do things in an online world, and whether we have a true understanding what the meaning of that is or not. And that goes into things like CDR and other things that are present in our sort of society in Australia. So yeah, it's going to be, for me, I'm very much excited by the kind of conversations you're starting and the movement.
Well, thank you, John. And probably I'll just drip feed a little bit more information that have had some initial discussions with Ridley from the Australian Open, Tennis Australia. Some of you may know that they released the AO art ball for the Australian Open earlier this year. And in my mind, that seems like a good token specification to jump 2 feet in, to use your turn of phrase, John, that where a ball landed on the court, you know, the court was divided into a number of squares, that in a sense was a data attribute. And if that happened, then your NFT was updated with the attribute that you had the winning ball of the match. Now, this, I think, is the same principle that can hold for if LawFi DAO issues tokens that represent attributes, and for example, I'm a woman, I'm a mother, Web3 for 6+ years, from a remote and regional background. If LawFi DAO seeks to perform that function, or maybe individuals might self-attest, and from that self-attestation, LawFi DAO might issue those tokens as the attributes that feed into our membership token, then this AO art ball, despite being related to tennis, actually becomes very helpful for an identity and a membership credential, which is why I love talking to Greg Oakford, and I do religiously every week, because I think that NFTs and the way in which we're learning about NFTs are giving us a more fun way to experiment with actually really important concepts around identity and cybersecurity. So he's a wealth of knowledge. Sorry to pick on you again, Greg. John, did you have any follow-up to that about your thoughts on the AO art ball? I don't know if you're familiar with that specification and how it compares to like W3C identity.
The W3, the W3C verifiable credentials sort of, there's been a number of online research and thoughts around how closely a W3C VC compares to a kind of the general structure of an NFT. And there is quite a lot of sort of similarity between the two, but I think that the intent is really quite different in terms of what they intend to enable. And you know, I've got, I think NFTs can be a really powerful mechanism, and you know, for the good. We all know that, of course, in some instances there have been some issues, more than some, I suppose. At one time, I think OpenSea had 80% of their NFTs were considered to be fake. So there are some issues to resolve, and some of them, of course, are to do with provenance and identity. As to, you know, is this a real NFT issued by the appropriate creator? And so on. And there's a wonderful crossover thing I was reading recently, that the Pepe the Frog meme one, yes, you know that one, where the creator of the frog created a DAO which was going to release a certain number, and the first buyer of the first one thought that they were going to get the exclusive rights to the first Pepe the Frog coming out of a pond drawing, and then they released another 90, and he sued the DAO successfully.
Yeah,
it's still ongoing. I didn't think that had been resolved.
It hasn't.
Oh, okay.
That one's interesting because they've named the DAO as a defendant, and it's just slid along so far. But it's also weird US court that.
I thought, okay, good, Michael.
This is the Pepe Frog butt one, right?
Yeah, that one.
Which is amusing. We're just going to make wonderful precedent with the frogs that read ass. Wonderful.
Yeah, exactly that one, Michael. I thought it had resolved, but okay, it's still going.
Unless it's settled. It was principally a claim against the artist on a representation that he wouldn't be releasing and selling more, and then he did.
That was exactly the story.
Yeah, but yeah, I remember because I had a look at that one, mentioned it at Blockchain Week, around the issue of, well, hang on, they're also suing a DAO, and what does that mean? Because there's a few lawsuits throwing out DAO.
Well, the other one, Michael, you're probably referring to is the BZX protocol.
Yeah, that's right.
And instead of a DAO, that's an attempt at defining it as a general partnership.
Correct.
Where all are jointly and severally liable. So I think I can update the community. I'll get a status of where both of those matters are at.
And I'm just going to jump off, but I did want to say thank you so much for organising. And I think I agree with you. And an identity sort of token is a very natural first step for this sort of thing, and is a nice level of hanging fruit on the tree. From a legal perspective, without creating too many thorny issues that are going to need to be unpacked, because traction of getting something going is quite important. And you know, I applaud you also for approaching it as a very experimental thing, under the same vein as, you know, what's the old saying? Thomas Edison may have found 2,000 ways that not to make a light bulb before he struck out the way that to make a light bulb, but each of those 2,000 ways were really valuable if it helped get towards the one that worked. So that's a really cool approach. And you know, if this whole effort got us to literally nothing more than a cool, updatable NFT, you know, membership-y kind of thing, it would still be a wonderful achievement beyond what anybody else has really done in the world around collectives of lawyers working together. And there's a range of, you know, different pivots that something like this could go to that'd be insanely useful and valuable for everyone. So really, really appreciate you being a guiding spirit of getting things moving on it.
Thanks, Mike, and thanks for taking the time to join in your very busy day. All right, so I am going to keep moving down. Gordon, you've got some questions around determining voting powers. So one for each member versus who has the most. What if I wanted to leave, and what happens to my vote? Gordon, yes, I can see you on my screen. So if you'd like to speak up and elaborate, please do so. or if it's difficult to come off mute, then then all I will say is the membership token is actually really crafty from a legal and tax perspective, particularly if it's non-transferable. So a lot of projects get into strife because they launch and they distribute a fungible token to often raise capital, or sometimes not, but it is transferable. And the fact that it's transferable, it can then, people speculate on it and the price goes up and down. And if money and tokens are being contributed to this DAO as donations or as some other form of fundraising, then with a non-transferable membership token, it really challenges these legal tests, particularly for unincorporated and then incorporated associations, as to whether it's not for profit and whether a member derives a pecuniary benefit. And so the community will see this playing out when we finalise the initial tokenomics and we apply to the Victorian body to register as an incorporated association, or maybe we'll decide to go down the route of a co-op. But it will be interesting to see the reasons for which the registrar accepts or declines based on the tokenomics model about whether there's a pecuniary benefit or not, because that's the large grey area at the moment, which a number of DAOs would benefit from having some legal and tax certainty over. Gordon, I don't know if you're able to come off mute, but please just interject at any time. John and Kelsey, I can see you two going back and forth with each other, which is fantastic. And okay, people having to jump off. Berkeley, I'm going to encourage you to speak up rather than me read this out, if you're still on the line.
Nice to meet you, Joni. Thanks for having me on this call. So yeah, typed out a bit of a blur, but
It's
I
okay.
know, yeah, I just think so much of like governance tokens are just sort of farmed or given away and then sold. And I think, yeah, like you sort of hinted on, like there needs to be meaningful thought going into these votes at some stage, especially when an organisation is truly decentralised and every decision is being informed by these votes. So yeah, just even like this LawFi having one vote on protocols at least, but the community having a discussion beforehand and making an informed decision and publishing that informed decision, I think would be really valuable and yeah, cool thing to go.
Thank you. And that in itself is legally important too. And so in the membership form, you will see a sort of initial section to read and that you need to accept. And it's something that is not quite terms and conditions, but warnings and important things for you to know, because this experiment is how to do DAO first properly. And if I was to put documents out just labelled author Joni Pirovich, or for example, author Vitalik Buterin, that's a point of centralisation and an ongoing point of liability should any regulator decide that the author of the initial specification continues to be liable for what they've put out in the world. So for all of you on this call, that might seem scary. You say, I don't want to join this DAO. Like Joni should be taking all of the liability. And these are the things that I think people should be told up front. And part of all of the language that we'll put on the membership form are all of the materials that other community members can benefit from, or even if you're a person looking to be involved in token projects, the things that you should be looking out for.
Do you think it might be a possibility to make that terminology less legalized and more lay so people actually read it? Because I think a lot of legal forms, people just click and say, yeah, okay, because there's so much stuff to read. If it could be made simpler, like the key things that are liability issues that you want people to take on board, because I do think that's a really big problem with so much stuff is legalized now and people just are blah about it. And I think if you've got to make something that's really about trying to show where the problems are, it might be worth making it really simple.
Completely agree. And I would love for there to be core contributors to this DAO that are visual and graphics artists. So, you know, there's plain language, but then there might also be videos and graphics that say, or that pictorialize this is the consequence of you making the decision, even in a flow diagram, maybe. So yes, would love that, Samantha. I'm going to keep rolling down. A few people have to jump off. And Jules, would you like to speak up rather than me?
Yeah,
read that
sure.
out?
Yeah, I just thought it was really cool, the idea of using NFTs almost as like little badges to represent legal opinions. And like, for instance, an exchange could use that badge that they get to prove that a listed token isn't a security or that they're maintaining their compliance. And they might want to even embed it in such a way that if the metadata or attributes of that token changes, then the token might automatically be suspended from trading or something like that. So it's just really cool thinking about all the ways that this could integrate out. And also the idea of incentivizing peer review. I think that's really cool. It's almost just like the consensus mechanism built into the actual like protocols themselves, where you're trying to get more and more confirmations on something so that you have a more solid sense of what's true. So I think that's really cool. And something that doesn't, like, it happens in a lot of other fields. It happens in science, it happens in with bug bounties and things like that in computer science, but it doesn't seem to happen in law. You just get one opinion that could be a bit biased, and then you just sort of pretend that there aren't other opinions. So that's, yeah, I love all of it. I think it's really exciting.
And for those of you that don't know, Jules comes to us with the double barrel of computer science and law. So that's where the comments are coming from. Love those ideas, Jules. Would be fantastic to see exchanges adopt it or be able to adopt it in that kind of way. And in that regard, it goes to, if this is effective, it could be a form of self-regulatory organization. And that's that real-time supervision and compliance that is ultimately there to protect consumers and financial market infrastructure, that it continues to be safe and sound. So I'll be adding you to one of the subcommittees. All right, now we've only got 10 minutes to go, and I just want to do a last whip round to anybody who'd like to speak up and say something before we close out the session. I might use the last 5 minutes to do a quick show of hands on the joining fee and those sorts of decisions. Anybody want to say something? You're all nervous like me. First workshop day jitters. That's okay.
Hey, Joni, it's Vic. I just wanted to say thank you. I'm so glad that you've done this, and I think that this is really exciting, and I think that that sentiment is shared across the group. So yeah, thank you so much for this.
No, thanks, Vic, and absolutely thanks for your help. Everybody check out the artwork when you get your POAP. All right, so joining fee, I might just open up. Does anybody have any red flag concerns as to if a joining fee is applied to the membership sort of from as early as next week, or should it be allowed to incubate for a number of weeks before any sort of fee is charged? Is there any allergic reactions or feelings either which way?
And I just think that if you're going to make it really, truly decentralized, there'll be people that won't. If you are going to do a fee, it needs to be fairly minimal, so people that can't afford it can actually still participate. And I wouldn't want something to be only for like that elite, financially able sort of communities, if you really want it to be truly decentralized.
Yeah, I agree. Well, and there's other DAOs where if there is a membership fee or a joining fee, they have the discretion to waive it if a request is made on financial conditions. But my feeling is that at this stage, unless we want to encourage behaviours of people to download something like a MetaMask wallet, go through the experience of getting some ETH, that it might be too much friction or too cost prohibitive. Even if it's like $20, it might be too much friction to convert the amount of ETH to pay for that. So no worries, John, for dropping off, but please, and plus gas, correct, Subin?
I'd also ask Joni just like what's the revenue raise going to be used for? So if I look at a membership-based organisation, happy to pay a membership fee when I know this is what it's contributing, this is what it's helped building. So I think that would be important. And I think the second is we really want to encourage core contributors from all different backgrounds to join. And does the membership fee enable that? Or are there other forms of, capital raising activities that could be more appropriate when we have built out something a little bit more solid? So that's sort of my 2 cents on it.
Thanks, Nathan. Yeah, very sensible. I think you're right. The proposition around how any initial funds raised through membership fees would be allocated probably needs to be disclosed before you charge it. Yeah. Yeah, Zubin, that's a good point. Okay, well then, in terms of, I'll make a note of that, and the minutes will actually either be circulated or in a repository. You'll get a link to find the document database. The other thing is, was anybody feeling strongly enough that they would like to be elected to the committee? And the official positions based on the Victorian model rules are President, Vice President, Secretary, and Treasurer. And I'm self-nominated President and Secretary at the moment, but if there were anybody that wanted to put their hand up now, you can say so, or in the chat, or afterwards we can talk about it. I'll take that as we'll talk about it afterwards. There's probably reluctance given all of the legal disclaimers that I've given you earlier. All right, so I think that those were the key things that I wanted to take you all through. We have an early mark is a good mark. Time is the most precious resource. The only other final document will be a document to record your time, including what you've spent participating in this first workshop today. If the tokenomics go as I would love them to go, there will be a token as part of our DAO that the only number in circulation is reflective of how many hours have been contributed by its people, and that's not tainted by whether that person has put more money in or more influence, that it's purely a metric based on the time contributed to the DAO. And I think that is also an experiment and an untested metric in this world, that we may find more utility and more community value by the DAOs that have the most number of hours tokens in circulation, but it's to be tested. So I'll leave you with that thought and welcome any other further feedback that you can provide at the next workshops or in whichever forum you feel is appropriate. Thank you again and look forward to having you on the journey.
Thanks, Joni.
Thank you, Joni.
Bye, everyone.
Thanks, Joni.
Bye.
Thanks, Joni.
Thanks, Joni.
Cheers, Joni. Thank you.